Greetings and salutations. Welcome to another episode of the Legal Beagle. Benny's back, ladies and gentlemen. Benny's back with some research tips and some interesting things he found on some land patents in Florida. And so it's an interesting episode. He's got some updates on his current case. The judge dismissed it and reinstated the case. Kind of crazy, but let's get into it. Without further ado, here's Benny.
Well, as I was saying here, I wanted to go and research the actual acts passed by the legislators of Florida. So in that case, I have to do a little bit of work to get there. And I was saying on the Florida statutes page, you can go and find the territorial laws of Florida, which is when Florida was a territory. And this was when land patents were being used to get settlers to go out into the territories that the United States had acquired, and they gave the settlers that land as their first deed through a land patent. Then the laws of Florida came about in 1845, and they continue today because that's when the state of Florida came about. So I'm going to go to one of the first territorial, the last legislative council of the territory of Florida. And in this case, the earlier ones have an index. The later ones, not so much. And so that takes a tremendous amount of time scrolling, looking for the acts you want. So you have here an act to exempt homesteads from execution, attachment, and distress. That's one of the first things that I really want to bring everybody to. So let's go find that act here. It's wordy, but I'm telling you, everybody, it's worth a read. Act, here we go. That every farmer seized and possessed of 40 acres of land in his or own her right, fee simple, and shall have actual cultivation at least 10 acres of the same, shall hold same free and exempt from execution, attachment, or distress, except for a violation of criminal law, or fines imposed by a court for taxes due on same county or territorial purposes, provided the lands do not exceed XYZ value. This doesn't exactly talk about giving you an exemption for taxation, just protection from creditors. So it's not subject. Well, the proprietor of such land shall be exempt from execution, attachments, or distress, shall have the power to dispose of the same by last will and testament, should the proprietor of the land die in estate, no heirs, then same shall descend to his or issue surviving at death, and should he lie without leaving issue surviving, then the same shall be allotted and set apart to his widow. Then that goes to death. So basically, the first homesteading was just to protect you from creditors, and you still see that today if you have to go through bankruptcy. That's what they talk about when there's a homestead on it. Then you have homestead exemptions that we see today, which we know are based on the use of the property. And that's where you need the income return from. So now we're going to go to, this was the first state constitution of the state of Florida. So you can actually go and read the original constitution that was passed, and it's very, very different from what you see today. Back then, we were freedmen. We had those defending life and liberty, acquiring, possessing, protecting property and reputation, and pursuing their happiness. That was the very first thing there was. We have that power, and inalienable rights are protected. No more, and many of these you will recognize. No person shall be put in the same offense, that private property shall not be taken or applied to public use unless just compensation. So again, private property is what we're talking about here. We're not talking about public property. We're not talking about real estate. Real estate is something you use in conjunction with a business, or it's held as an estate, like a ladybird deed, or something with your marriage license. So there's a few little minor definitions here. Now, this far back, that free white men of the state shall have the right to keep and bear arms. Obviously, this is before the Civil War, so only white people had rights at this time. And so like the free white men of the state shall have the right to keep and bear arms. So it's just the whole Constitution of Florida again, as it was back then. Lots of interesting things. They talk about the duties of the tax collectors. You could spend hours going through this, and I would. This one is a little bit later on. This is the Acts of 1873. What was the one I was looking? An act providing for the acknowledgement of deeds and other conveyances of lands. So somewhere in there, they'll talk about what you want to see, what are the rules to those, and they change them each time. An act to amend providing the setting apart a homestead and personal property to be exempted from forced sale under process of law. So again, there's due process. Our rights are being protected. A bill entitled to an act to protect all citizens of the state of Florida and their civil rights and furnish means for their vindication. You can see the progression of equity, equality, and I'm trying to incorporate the 14th Amendment. Now, here's something else. They had to have acts to incorporate a company into the state of Florida. It's vastly different from what we see today. It's not the easy, casual process. That's how you know property was being used as real estate back then. It had to be literally by an act incorporated in.
Wow.
So
That's
these
crazy.
are the things you can learn, you can study, and you can see where administrative changes came later on. So just go through the different types you have. Now, here we have Murphy deeds. Everybody remembers in 1929 we had the Great Depression start because of Black Friday. And at that time, 90% of taxpayers were actually corporations. So when they crashed, all of their lands were taken by the state. So you have the land boom of the early 1920s, the land bust of 26, the worldwide depression of the 1930s destroyed Florida's land-based economy and produced a massive tax revenue crisis. So what they did was the 1937 Murphy Act, which stimulated the economy and forgave delinquent taxpayers a significant cost to taxpayers concurrent on their tax obligations. Murphy deeds returned state-owned lands to tax defaulted landowners, reserving a right-of-way easements for future construction. So this is how we have the public road laws, and I have a suspicion that for the vast majority of the United States back then, something similar like this happened, and that's how we had a good change into our administrative state of today. So I'm trying to find this in the legislative acts, but there's actually 4 different 1,000-page documents to go through.
Wow.
So once I find that, it's just keeping up with it, which is why I look like I have no sleep all the time.
You look great, Benny. You look great.
So tax certificates were redeemable at giveaway values set at the certificate holder's investment plus 3%. They were redeemed by the delinquent landowners. Certificates not redeemed, simple title vested in the state. So at that point, I think the Florida Bureau of Land Management did their own version of land patents to convey property back to citizens. But this is where I think we started overtaxing the people and losing private property rights.
So you think that the land patents were the original way everything was administered, and then when we switched from that,
the government had a way to convey it, the property from public sphere into private. That's what it was meant to do. From there, you were supposed to go to the clerk of the court and record deed transfers.
Okay.
If it happened to be the land patent you were passing on the land patent. If the land patent was sold to a company and it was broken up, then you had the warranty deeds. But the way they wrote warranty deeds in Florida puts a taxpayer ID number on them and literally forces an incorporation into the assessor's lands. That's one of the things I'm looking into trying to change. But first, I got to get off the dang tax roll, which is what we're going to succeed in doing.
There you go.
So the land patents are just a piece of paper that said government entity gave private person and the land is phased out of public domain. You can go to the Homesteading Act of 1865 all the way to 1976 to see the production of that.
Gotcha.
No matter what, if you hold your land fee simple, you have allodial title. It's the highest title you can hold. Some states recognize land patents, other states do not. It just depends on what's going on, and you're going to have a feudal battle. Pick these fights wisely.
Good advice. Good advice.
You know, I'm watching a major land patent battle in Florida courts right now that looks absolutely ridiculous and full of patriot mythology. I don't even want to show it to anybody. But for those of you who want to talk about you can foreclose on your mortgage and keep your property with your land patent, not going to happen. So you're going to go look up this Supreme Court case here, 18-840-80. This was filed March 13th. This was the last attempt by this guy, Kevin Fung, to get his property from being foreclosed on for a sheriff's deed for not paying his mortgage. This went all the way to the Supreme Court, and the Supreme Court went, get out of here. So it's not going to work. Don't bother. Go look up into here. Go look into here. Why? You'll see all the pertinent cases to land patents. But it doesn't matter the way he used them because he's not paying his debt.
Makes sense.
So another thing that I think is important for everybody to go and read are congressional records. This is the same thing as the acts that we were just reading for the state of Florida, except this is the United States congressional records. This particular one here that I have is 1909, with President Taft's letter to the House, to the Senate, and House of Representatives concerning the 16th Amendment itself. It is the constitutional duty of the President from time to time to recommend the consideration of Congress such measures as he shall judge necessary and expedient. In the Senate, the action of the Finance Committee in the course of the debate indicate that it may not agree to this provision and is now proposed to make up the deficit of the imposition of a general income tax in the form and substance of almost exactly the same character as that was the case of Pollock Farmers Loan and Trust Company, was held by the Supreme Court to be a direct tax and therefore not within the power of the federal government to impose unless apportioned amongst the several states according to population. To those who don't know what apportionment means, that is when the government says, this is how much we have as a debt. You have this much population, you get this chunk of it, Florida, you have this much population, you get this chunk of it, Iowa. And then the states themselves set it out by counties and they collect the tax. We don't do that anymore because of the way the IRS is taking over. So I therefore recommend the amendment to the tariff bill imposing upon all corporations and joint stock companies for profit, except banks, savings banks, and building and loan associates, an excise tax measured by 2% on the net income of such corporations. This is an excise tax upon the privilege of doing business as an artificial entity and of freedom from a general partnership liability enjoyed by those who own the stock. Right there, the 16th Amendment is not meant to apply to us. It cannot. So Taft is telling us it's only for legal entities. This is where property tax comes into play, because a property tax is a tax on the corpse of the estate that you earned the income from. In other words, the land. So that's how property taxes really came about right about then. And then it kind of got exploded into something else entirely.
Very insightful.
Now, net income is preferable to one proportion to a percentage of the gross receipts because it is a tax upon success and not failure. It imposes a burden at the source of the income at a time when the corporation is well and able to pay and when collection is easy. That's not what they're doing to us today.
No.
Taxation today is not easy. So you can go read all of these things. And for those of you who want to see this, this is on page 3344 to 3345 of the 1909 Congressional Record and Senate. So that's where you can go find it. You can find lots of fascinating stuff. This is 52 pages, and they talk about anything and everything. Like literally, this is the history and a conversation of our Congress. Go read this stuff, folks.
And it takes going into these congressional records to know what they're trying to do in the bill, right?
Yes, because the statute is a shortcut. Because they're presuming you know what it means. And nobody ever reads this stuff. I'll bet you the vast majority of you have never been to your state's capital. You've never even attended a legislative session. I've gone 7 years running now because my passion has been cannabis and hemp.
Mostly boring proceedings, but every now and then it livens up.
I would not call them boring. They are angry sessions because people are standing up for your rights, and these things are disappearing. So don't presume that what you think is going on in the Senate is going on. You have to remember, my tax collector is the ex-Senate minority leader. He should know all of this shit, and he doesn't.
Yeah, our elected officials, they depend on the class that is there permanently to guide them on pretty much anything. They just come up with, oh, this is a good idea, write this up for me, and they implement it, and it turns into be a disaster most of the time.
Presumed power. That's why our teachings here in the Legal Beagle are very important, because we're learning the rules of statutory construction. We're learning what the intent of the law's law, what the founding fathers were. Just pick up random books on stuff. You should have the Federalist Papers, the Anti-Federalist Papers, just a laundry list. And don't get me wrong, this stuff is boring. But you're going to find gems in there. You're going to find tidbits, and just hopefully will make you think, because these were the arguments published in newspapers, which was the social media back then. There was no other way to get this around. So they used anonymous pen names. Let me see here.
And this is the kind of information that we are documenting on our Telegram channel. So all the documents, for the most part, that we
Yes.
talk about here, or at least on individuals that have written things and participated in federal litigation, all are on our Telegram channel, the Big Sib Chat. And there's a couple groups that splinter off from there that we've used to supplement these things. But that's where you can find all of these posted documents and recorded knowledge and digested stuff. And you can get opinions on who posted it and what they think about it. And you can have discussions there. And that's the whole purpose of what we're doing here, is to try to reach some other people that are interested in these topics and don't know how to go about researching it, don't know how to about finding it, don't know what it means sometimes. And so we're trying to break down as much as we can, as fast as we can, to let people gradually learn along the way.
Absolutely. Now I'm going to catch everybody up on what's going on with my pleading right now. About a week and a half ago, last Thursday, not the previous Thursday, the judge signed an order dismissing the case and telling me that the gravamen of the complaint was, yeah, we can't tax homesteaded real property. I'm like, wait a minute here. We're not a real property case. We're not a taxation case. We're a civil rights case. And I'm trying to get this guy on the phone. What's going on, Judge? Give us some information here. Why'd you close it out? So they finally, I rewrote my pleading. I went from 90 pages all the way down to a 40-page pleading. They're much, much better, much cleaner, much neater. And then from there, I submitted it. And then there was an order closing the case entirely 3 days early from the amended date, which was terrible. So
Have you?
the
Are they going to
judge
let?
reopened the case last Thursday, and this time he's requiring me to post a short memorandum in support showing why I'm not barred by the Tax Injunction Act. So this I'm going to submit tomorrow. And I can keep memorandums short, people. They're not really a place to introduce extra evidence, not a place to argue. They're not a place to, you got to stay within the four corners of your pleading on these. And the shorter you can keep them, the better.
Well, a lot of the lawyers in our experience have used the memorandum to make all of their arguments, and they make their motions really, really short, because those are the ones that they really have to sign under penalty of perjury. And the memorandum is kind of where they argue all this legalese stuff, and we see that they're getting longer and longer and longer, when it's really supposed to just be about case law and supporting your motion. But that's not what's going on. But this is how it's supposed to be done, folks.
But that's sure not happening. So in my case, the burden of proof that you're a taxpayer is very likely to be on the assessor. He's the one who's supposed to be making sure that he's assessing things correctly. So I have just one discovery question, folks. Literally, just many others, but the primary one is provide a copy of the income return used to create the assessment, which the defendants have admitted they do not have under Florida Statute 119, which is public records request and is penalty of law. There is no speedy, efficient remedy for plaintiffs in the state court, as the remedy is there specifically for taxpayers. We're not taxpayers subject to the ad valorem property tax, which is income return based. Our rights are enumerated in Article 1, Section 2. Plaintiff's property is protected by a Florida legislative act providing for a homestead and personal property exemption from forced sale under process of law by creditors. Our two civil sheets on the docket indicate it's a 440 are the civil rights, not a real property. Now, to get out of the Tax Injunction Act or any type of injunction act, I'd like you guys to remember one thing. Anytime your civil rights are at risk, an inalienably protected constitutional right, the purpose of 42 U.S.C. 1983 is to make sure that your due process is protected at all times. So if they want to throw an injunction act at you, there's lots of ways out of it. Mitchum versus Forrester is one of our favorites here. Title 42 U.S.C. 1983, which authorizes a suit in equity to redress the deprivation under color of state law of any rights, privileges, or immunities secured by the Constitution, is within that exception of the federal anti-injunction statute. So this is good for us. The district court is held to have erred in holding the anti-injunction statute absolutely barred its enjoining a pending state court proceeding under any circumstances whatsoever. So right now, that shuts down the Tax Injunction Act. This one is a very recent case. I want to say last year, Axon Enterprise Petitioner 2186, citing Judge Thomas. In sum, whether any form of administration education is constitutionally permissible likely turns on the nature of the right in question. If private rights are at stake, the Constitution likely requires plenary Article 3 education. Conversely, if privileges or public rights are at stake, Congress can likely foreclose judicial review at will. So if this was my hemp company arguing over a taxpayer privilege, back to the state courts we go. But because this is about my private property rights, my civil rights to own and use and possess property, we are protected. Florida Constitution enumerates taxpayer rights in Article 7. So there's a clear delineation between the two. You guys have to remember this. Article 1 is for us, Article 7 is for taxpayers and finance. There is a classification for a tax discount and tax assessment called a homestead exemption applied to a classification of use, residential or agricultural and whatnot. So this is where I made distinction inside of the four corners of the pleading. In paragraph 32 of the amended pleading, a taxpayer is defined as personal or other legal entity. And I have a definition of nocitur socius at the bottom of that paragraph. The assessor
that's
can
a
only classify
statutory
real property by using records provided by a taxpayer to determine if a taxpayer is liable for the tax under the code. So I cited the three case laws that I talked about last time with you guys. Dillard versus Singh, Lerner, Walt Disney World, Muckenfuss versus Miller. The appraiser has the burden of going forward and presenting testimonial and documentary evidence of explaining how the appraiser satisfied each of the just valuation criteria. So right there, I threw it right back on the courts and the appraiser. It's up to you guys. But I made sure to do this. The assessor has admitted he does not have the required income return. And Exhibit F, the assessor knows he must consider the intangible return filed. So now, again, we're using the court's power. We're moving the honorable court to inquire of the defendants if they can provide the required income return showing plaintiffs or taxpayers as a means of plain, speedy, and efficient remedy of utilizing the honorable court's time. Boom. We want to know.
Put it on them, Benny. Put it on them.
So that's been tiring, but quite frankly, also exciting to be on the front lines, doing this with the crew, doing this with the team, because we're all in the chat room going, how do we get out of this hot mess here? And it's only because we're working together that we're going to be able to pull this off.
That's right. That's right. And the more that join the fight, the easier this is going to get, because the more pressure we apply, the more your average person in government's going to go, that doesn't seem like it's worth my trouble. I might just want to bow out of this. So we're not at that stage yet, but I know that we're coming to it.
Yep. Now I know of somebody who's about to make a claim on the bond of in the same county here, everything, and I'm like, what the hell are you doing? You're wasting your time. You're wasting your energy. You really need to be learning how to write a pleading and doing what we're doing here. All the resources are free. I'll give them to you. Just don't waste your time on this. They're going to go ahead and file this whole thing and just give more money to the lawyers.
Well, talk a little bit about what that process is that he's trying to describe, and why it's pretty much patriot mythology.
Truthfully, I don't know much. They're trying to use some patriot mythology and say that you can make a claim on the bond of an official. And no, you can't do that until you have a judicial remedy.
Right, and that's the same.
They're not going to respond to affidavits. They barely even respond to me going to talk to them in person.
Yeah, and so the bond thing is what a guy like Cal Washington claimed to have done, and ended up defaulting the Queen of England and all this other stuff. And now he's going down some other track, empowerment movement or something. I don't know, but he's off in the weeds and is not following the black and letter writing of the law.
And we're trying to work with the black letter of the law here, folks. I mean, we're using Dr. Graves' excellent course just to get your toes wet. Learn the basics of writing a pleading. Learn the rules of the court here. That's what's going to be effective, because now I have the county's attention the second I drop that lawsuit. But if I hadn't put in all the time learning everything, I would have just been paying lawyer fees. Now I have them backpedaling. As long as they're backpedaling, we have a shot here. But I don't it's going to be very difficult for them to settle with me because my intent through this whole process is change, real and true change. Knowing as a real estate agent, I have the ability to go before the value adjustment board and say, where's the income return? What are you going to do from here? But first, I need a process out of them.
Right. And so how long would you say it took you to from really getting into stuff that's important to writing your first complaint? How long you think it took you to do that?
Keeping in mind that I had basically the same grass lawn issues Tate was when I first had to start studying ordinances and the codes and what's going on here? Where are they getting this power? And I kept at it. For me, it was personal research into land patents at that point. I'm reading case law. I'm reading Marbury versus Madison. That's fine. You're picking up stuff, folks. You're introducing yourself to the language. I'm 2 years in. I'm a good, solid 2 years in. And I would say that I really began studying this. And I joined Alphonse's group last February. So it's been just over a year in Alphonse's group, listening, learning, getting chewed out by him for asking some dumb patriot questions. But yeah, what's my starting point? What I need the feedback.
Yeah, we've all gotten that.
I began to truly write my pleading October of 23.
Yeah.
And 15 revisions, easy.
Yeah.
Easy, before I even felt comfortable putting something out and going, read this, and the people are like, what is this? So you just keep at it, keep rewriting it, post it in the chat.
And with the resources we put down in Telegram and the knowledgeable people and experience that we have now, do you think it's getting faster for people to start today and write their complaint? Or do you think it's about the same? It's going to take 2 years.
I think it will get faster because we have excellent teachers. People who are taking the time to try to explain this in a reasonable and sensible fashion and just point out mistakes. We all make mistakes. And if you see us making mistakes, you're going to be less intimidated going down through this. So please, all of us have dug in the weeds.
I've made my fair share of mistakes for sure.
So don't give up in this case, but do take breaks to reorient. So I thought I was ready December to file this. Nah, next month goes by, still not ready, still getting evidence from people. Nah, this isn't done. Finally, I'm ready to file it. I have my own small Telegram group of just Florida tax people. And that's okay. That's my legal team, if you will. They're the ones who give me the honest critique before I throw it out into Alphonse's group and get my chewing going on. So start your own groups. You should be hunting. Anybody have a property tax group? Everybody have this or that. Big Sib's group, I post my property tax stuff in his Florida chat room, but there's a lack of interest there. So build your own. Don't feel intimidated doing that either.
Right. And do you participate in our law group too, or just Alphonse's?
Say that again. Do
you participate in our Big Sib law group, or just Alphonse's?
I'm in the resource group. I'm reading quotes. I try to share things that could go into there if I feel it's valid. I'm in Alphonse's group. I'm in the Big Sib group. There's a couple other ones here and there that I'm in. Doesn't mean I'm regular participants in them. I have my preferences, but somebody's going to post something that catches my attention that I could use later. That's why it's there.
Right, and so what my point was, the Big Sib chat is kind of our public group that everybody can join, and it's divided in topics by state, so people of similar states can get together and do on projects. But we have 3 other groups within our group that we share 2 of them with Alphonse: the law documents and the law resources, right, for the case law. And then we also have the law group, which is where most of our people that are filed lawsuits that talk, that's where we talk serious about all of that stuff. So I was just seeing if you were in the law group as well, and using that as an example to
Yes.
put this out in the
Yes.
public so they understand that
Yes, absolutely. I get ideas for my pleadings or responses from other people. There's somebody in there who's at least in the same district court you are, so you can chat them up and get these resources. So again, they have paralegals. We don't.
That's
We have
right.
peers. We have peers who are. I'm studying law on a Friday night near midnight, and so is a lot of the people in our group.
Yeah.
That's our hobby. I don't care to go out and drinking. Just people are boring now. No offense, folks, in general, but it's just I don't care about football. Yay, kick that sports ball thing over there. I'd rather have a concise conversation about law, which I'm not going to find in a bar.
Not often. Not often. Yeah, I was researching my Chattanooga case and yesterday, and I came across another similar complaint filed in the same district court as me against the same defendants, and I called the lawyer up and I said, "Well, can we share some things? Maybe we can accomplish justice here." "Oh, I can't share any discovery or observations that I've made in this case with you. There's privilege, this, that, and the other." And as soon as he found out I was pro se, he didn't want to talk to me any longer. And it's kind of took me back a little bit. I'm like, what is going on? We got the same judge, the same magistrate. We're about 20 case numbers apart. So why do we have the same judge and the same, if they're randomly chosen? And why wouldn't you want to share information if you're going after the same defendants? Well, we know why, because the bar members are there to protect each other. And so I guess that's what we're going to have to do as well.
And again, many of these lawyers are wonderful people. I know them, and
True.
many of them in daily life. I have great conversations with them. They're honest, down to hardworking people.
Mm-hmm.
But when they put their job hat on, they're sharks. They're there to get you. Kudos to you. I'm going to be just as nasty back to you, but if I have to be, and I don't want to be. So expect a fight. It's just a nasty drag down fight, because they're going to be abusive to you because it's their turf. What are you doing here, pro se?
Right. This is money I could have been making from someone that is litigating some case. So they could have been paying me, and so they see it that way as an offense, and rightfully so, I think, ultimately. But we're not at any stage that they should be feel threatened at this point.
Yep. So, I mean, I'm excited. I'm excited to do this. I'm excited to keep this case going and create a new future for us. And if you're watching this video and you want to join in the fight, pick up your pen. A darn thing is mightier than a sword. And all it takes is a dozen of us, and that'll turn into 144 of us, and that's going to turn into some over 1,200 of us. And next thing you know, we're overwhelming the courts. That's when they have to make a decision. Do we keep this silliness going, or do we just put a stop to it outright?
I don't think I can end it any better than that, Benny. I appreciate you coming on and sharing all your updates with us. We look forward to the next step and your further research. Well, like you said, you're always reading, so we're always fascinated by learning a little bit more. And land patents were on the topic of agenda today. So thank you again. I'll give you the last word.
Today's last word, don't forget to have fun. Because doing all of this, you're going to look up and it's hours later. Go take a walk, relax, enjoy nature, enjoy life. That's what God put us here for. But don't forget to defend yourself, protect your rights, and stand up for yourself and others at all costs.
Thank you, Benny.